Good morning, dear ladies and gentlemen. We are starting this session, which is called Compliance, Global Legal Trends and Perspectives. We have selected this topic and this emphasis on the word legal in this title. It is not occasional. We wanted actually to stress that we are going to discuss legal techniques related to this fashionable word and also discuss various tendencies that we, as members of the legal community, observe. This panel discussion is a continuation of our discussion that we started last year at this forum. And we spoke a lot about this term. This term, compliance, is not clearly defined, although this topic has been very popular. And I would like to thank you all, because you came here at 10 o'clock. And this time, I understand, is quite early, because yesterday we had cultural program events. But this demonstrates that this notion of compliance attracts attention of a great audience. First of all, we, as a legal community, need to agree what we are speaking about when we refer to compliance. Yes, this is a borrowed term, at least for the Russian law, and in its everyday use, it would be reasonable to say that this is a number of legal instruments disregarding the areas of law, and it is aiming at opposing corruption and various preventive measures. And it is about working with anti-corruption work. And if there are some negative cases, when we see a corruption case, then it refers to a number of procedures related to eliminating consequences of this, and again, preventive measures not to allow it to happen in the future. So this is a very wide definition, but it demonstrates what we mean when we speak about compliance. So this is mainly about anti-corruption. Why did we want to stress these legal tendencies? This topic gives us a great challenge for the law theory, because non-compliance or various corruption cases, they can occur in all possible law areas, because we see this risk absolutely everywhere. And if we speak about certain legal measures and regulatory means, there's a notion of expert evaluation of normative acts, for example. And here, this risk is also quite obvious, because certain acts may allow certain ways of certain types of behavior. So that is why we wanted to focus on these legal choices. And we believe that we should meet this challenge with the help of specialists from quasi-professions. There are various commissions and committees that try to work with these problems. And these are quasi-legal committees. Whether it is really effective only the future will tell us, but we, as members of the legal community, we need to develop definitions to identify our ways and methods, and this is what we wanted to discuss. So this is the context, the environment in which we would like to discuss this anti-corruption compliance. We have a great panel here, and I would like to thank all my colleagues who joined us, and I would like to introduce them. I will start with Laura Brank, who is a managing partner of Dekert, Russia. She is based in Moscow. She works in Moscow. And it's very hard to catch her anywhere in the world. And I'm very grateful. Laura arrived today from Luxembourg, and she joined us here immediately. Now, next. Representative Daniel Levin, who is a partner of white-collar crime practice. Again, I'm using English words in Russian, but this is what I use. White-collar crime practice. He is based in Washington, United States, and he will be telling us, but I will speak about it later. Then Elizabeth Robertson, she came here especially for this session. She is a partner, and again, she works in white-collar crime. And she's also a manager of this practice. She works in London, United Kingdom. Then Vladimir Lafitsky, who is Deputy Director of the Institute of Legislation and Comparative Law under the government of the Russian Federation. Vladimir Ilyich is a member of a number of committees. I'm sorry, I don't have a printed version in front of me, but maybe you could mention all those committees you are a member of. I am a deputy in the commission of this is democracy through law. Then I'm a member of the scientific law of the Anti-Corruption International Academy. This academy was established in Austria, and 70 countries are members of this association, and they specialize in anti-corruption compliance. This is very briefly. Thank you very much. And we are going to speak about this aspect in the context of the International Arbitration Court in Paris. And this topic will be represented by Vladimir Hvaley, who is Vice President of ICC Commercial Court of Arbitration in Paris. And also he is a partner at Baker & McKenzie. One more key representative, Christian Albanese, managing counsel from ICC International Court of Arbitration, is going to join us a bit later. I met him yesterday. We also are going to hear about practical aspects of working with such risks. Dias Asanov, who is a compliance officer from Siemens, Russia. And I would like to answer a question from PVC. Anna Zaloeva and Inna Fokina, they reacted to my invitation just yesterday, so I asked them to comment on some practical aspects of anti-corruption audits. They are going to join us again, probably a bit later. Oh, this is Christian. Christian is coming. Right, let's start. I would like to give the floor to Laura Brank, who is the managing partner of Decade Russia LLP. And we are going to start with the following topic. This is M&A. We keep saying that there is influence of corruption factors on mergers and acquisitions. But we would like to discuss specifics. We all know that due diligence is conducted. When we speak about M&A, sometimes it can be a deal breaker, and sometimes these risks can be managed. And I would like to give the floor to Laura.
Inviting me here today. It's such a distinguished panel, and I have great pleasure speaking with such experts. And Alevtina has done a fantastic job in putting together a wonderful group of people and a very interesting panel. As Alevtina just mentioned, I'll be speaking about compliance in the M&A context. See if I can get this to work. So first, just to talk, why undertake a compliance due diligence when you're acquiring a company? I find quite frequently that companies don't want to undertake that cost. They think, oh, we'll just find something bad, and then we don't want to know about it because then we'll be liable, or let's look at that later after we acquire the company. And so quite frequently, in many cases, people don't look at compliance and then later find out something very bad, and they're paying the price for it. Because generally speaking, a company can be liable if a violation of the Foreign Corrupt Practices Act occurred prior to the acquisition. Now, if it was a company that wasn't subject to the FCPA pre-acquisition, then you can't, after purchasing the company, say, oh, let's go back. The company before you bought it violated the law. It doesn't mean that, but it does mean that once you do buy the company, and if it wasn't subject to the compliance procedures under US or UK law, you definitely, post-acquisition, need to make the kind of changes in order to bring the company into compliance. So I'll talk a little bit about that and what that really means and how the government has interpreted this in other cases. And there have been many cases, particularly over the last decade. Another reason why you want to look at this is the valuation of the company. The fines, as everybody now knows, are very large. And if a violation is found, the company, this new company that you've suddenly purchased, the whole business case may go out the window because you're paying fines, or you found a company that has a lot of problems that is going to take a lot of training and a lot of money to fix and bring it up to the value where you thought it was going to be. Another reason to undertake during due diligence a compliance process or to check on due diligence is because you want to have an ability to walk away. If something is really bad and you don't think it's going to be able to be fixed, you want to walk away from the deal, just simply. Or you might want to restructure it. And there are ways that you could potentially restructure it, but the whole reason there is successor liability is exactly because they don't want, the U.S. government as well as other governments, don't want somebody to get out of a problem or get themselves out of liability simply by restructuring an entity. So they're generally not in favor of you just trying to restructure to get out of a problem. So that has to be done very carefully if you undertake it. Another reason that you want to take compliance due diligence is to really understand the culture of the place, the company you're buying. How do the people operate? If they're stealing at the top or if they're paying bribes at the top, does that permeate through the corporate culture? Are you buying a company where people think it's okay to put in false travel expense reports or really aren't careful with internal controls? Because that type of thing, if that's happening within the company, people get knowledge of it and it really permeates the whole system. So you really want to make sure that you're buying a company where they have the proper internal controls in place and people respect the law and respect procedures. Another reason, and this has happened, and Alevtina has seen, we've done a corporate film where oftentimes a company may be very successful because they have been bribing government officials. And this becomes an important part of their business. They're very successful. And once the government changes, or you find out that this person has been bribing officials and you fire them, suddenly those contracts could go away. So that may have been a very important factor when you looked at the company. Wow, they have all these government contracts, or they have these great contracts with a state-owned entity. We really want to buy this business. And then you find out really that business doesn't exist anymore because it was all because of bribing. So just a few further words on this issue about successor liability and why due diligence is so important in the pre-acquisition stage. About a third of the cases in the US under the FCPA, the Foreign Corrupt Practices Act, are successor liability cases. So obviously, people are inheriting these problems. And what they do with these problems once they inherit them means everything. It absolutely means everything, because you could potentially, as the acquiring company, come to some agreement and get rid of the problems by entering into an agreement with the Department of Justice and the US SEC, or some kind of agreement to pay some small fines in order not to be prosecuted in the future. So that underlines the importance of doing that due diligence and finding out exactly what went on before you acquired the company. And DOJ and SEC have said specifically the nature of your due diligence and the scope is really going to be determinative for them in whether they bring an action against you and what kind of penalties you may be subject to. So they really look at it. They don't want you just checking the box, yes, we talked to this person, we talked to that person, they said nothing happened. That's not what they're talking about. They really want you to go in and do proper due diligence, get behind the numbers, and really try to understand the business you're trying to acquire and what would be relevant in that context of the business. And they also want you to look for the, when you see a red flag, I'm on the right page, yeah. When you see a red flag, follow it and try to understand what's behind it. There's a resource guide. In fact, it's so important I brought it with me. This is a resource, a guide that's put out by both the Department of Justice and the SEC that's very, very helpful because it gives hypotheticals and examples, and it tells you what you should be doing when you acquire a company. It tells you a lot about successor liability, and it's very, very helpful if you have a question. And people always have questions during an acquisition. Almost always, you find something. You find something that's going to raise a red flag, and you're like, well, okay, they paid some money to this charity. We're not sure this charity is really a charity. How do we deal with this? And there is a process that you can go to the SEC or DOJ and get an opinion without, providing names, et cetera, saying, and these are the circumstances, and how would you react to that? So a lot of people don't realize that you can actually try to get some answers in advance. So this thing covers quite a few issues about the FCPA. But just keep in mind, it's non-binding and it's informal, so you can't rely, well, this is exactly the same as the hypothetical you had in the resource guide, so we just followed that. So, I mean, obviously you can't do that, but I do think it provides very good guidance. I think it's important, I've put this quote out there, DOJ and SEC evaluate whether the acquiring company properly incorporated the acquired company into all of its internal controls, including its compliance program. Companies should consider training new employees, reevaluating third parties under company standards, and where appropriate, conducting audits on new business units. And that's obviously all post-acquisition what they would look at. And that's how some companies have avoided liability, because even if they found a problem, they've gone to DOJ and SEC, say, look, we found these problems, we have an action plan, here's what we plan to do. And this is what the guide says. These are the things that you should look at doing. So just a couple of case studies along the way here. And I'm using two of them because it's the same company. So you can see the difference in approach the company made the first time around and the second time when they knew that there were going to be issues of corruption. It's Pfizer acquired Pharmacia Corporation in April 2003 for $60 billion. Pfizer HCP, which is a subsidiary of Pfizer, entered into a deferred prosecution agreement with DOJ in order to resolve charges that Pharmacia, a subsidiary of Pfizer HCP since 2003, April, had made improper payments to distributors and government officials in Bulgaria, Croatia, Kazakhstan, and Russia. For example, in Russia, what they did is they paid sales discounts into bank accounts, into offshore bank accounts. In Croatia, they made regular payments to government officials, doctors, and hospital administrators from 1997 to 2004. Importantly, that was post-acquisition. So what happened is that Pfizer acquired the company, continued this system of paying these doctors, continued with these payments for some period after acquisition. So probably what happened, and we've all been there, what happened is Pfizer bought the company, said, well, we discovered all these problems, they're making these payments. And then the employee said, well, we can't cut the payments off because if we do, we'll lose these contracts. So the management said, okay, fine, let's do this. We'll continue, but we'll end it at the end of the year, and then we'll find other contracts or do something different. And unfortunately, DOJ and SEC did not like that approach. That's not what they're trying to encourage companies to do. They want you to come in, report these problems, and work out a plan to fix the problems. So they got hit with some pretty big fines in the period. They don't mention the level of due diligence that was done either pre or post-acquisition, and obviously that was also a factor for Pfizer. Fast forward to the next case, which is with Wyeth. Did I get it there? Yep. 2 minutes? Okay. Okay. In this case, what happened is Pfizer purchased Wyeth in 2009 for $68 billion. The SEC, however, in this case, noted what Pfizer had done when they purchased Wyeth, in that they did the thorough risk-based due diligence of Wyeth's global operations and reported the results of the due diligence review to the Commission within 180 days of closing. They had found improper payments, but in this case, DOJ declined to bring any criminal action against Pfizer. They cited what they had done post-acquisition, and so the fines that were paid were relatively small given the size of the deal. As I only have a couple minutes left, let me just skip ahead. I think probably the most important thing to mention is when you can't do due diligence. And that's really this Halliburton case, where Halliburton was buying a company out of bankruptcy. They had very limited ability to do due diligence. They went to the government beforehand, said, look, we have very limited ability to do due diligence. We don't know what we're going to find. We may find some stuff. Will you give us some time to fix those problems if we do buy this company? And DOJ and SEC said, yes, we understand. You'll have a period of time, but here's the program by which we would like you to comply with certain milestones, certain timing, and they did so. And as a result, this has created a new standard in terms of what are best practices after you buy a company, what sort of things you should institute. And I've put in the presentation, do people have ability to get a copy of the presentation? Okay, okay, okay. Well, if you want a copy, then, please, you could email me and I could send you a copy.
I think that will be your email address or the contact.
Yeah.
They can contact the forum, and the forum can have a copy of the presentation.
Okay.
Transparently.
So what I missed, because there's a lot of speakers and I don't want to take up anyone else's time, but thank you very much for your attention. I'm happy to answer any questions afterwards.
A few questions from me. So, да, говоря по-русски.
I'll switch to Russian. A few questions from me, and why we are discussing M&A, a technical issue, and FCPA, because what we're talking about is an international level, and maybe bringing this closer to the Russian realities, because we understand that when you have two Russian companies merging together, if both are totally Russian, then this might be something that you can have as a something to look at, a target to look at the trends. But it's true, there's very little Russian, 100% Russian business in Russia. Mostly businesses go beyond the limits of borders of one country. So everything Laura is talking about is applicable. That's why we wanted to discuss this. So Laura, my question is that compliance and due diligence is a must. That's an absolute must in the due diligence system pre-acquisition. This is, how to put this, encyclopedic knowledge. Compliance, due diligence. It's not something you can or cannot do. This is something that must be there. Okay, good. Now, can we assume that the price of the acquired asset depends directly on your results of your due diligence?
You need to evaluate that as part of it, and in certain of these cases, and there have been some very large deals where you've detected that there have been some major abuses, and you've gone to the seller and said, look, we need to adjust the price, or oftentimes you need to fix this problem yourself. We don't want it in our name. We're going to buy a company and then we're going to be prosecuted. No, thank you. You go fix the problem, and then we'll buy your company. So it's a very important component of the due diligence.
Еще маленький вопрос, понятно, что ответ может.
Another important, brief question. Isn't there a risk that such a defense can be used as a mechanism to manage the acquisition price? The mechanism of changing the price. So is there any remedy in this respect?
Defense, and but not if you're vis-a-vis the government. If you've detected it, then it shows you had knowledge of it, and if you didn't put the proper controls in after acquisition, you're going to be found liable. But vis-a-vis the other party, the counterparty, even an indemnity or a warranty, may not protect you if you get some kind of a warranty from the other party with respect to FCPA. You should absolutely ask for it, but will you be able to recover? It's not clear.
Понятно. То есть.
Okay, so.
Yes, of course you can, but because we have such a long panel, can you make a note and then in your presentation you will cover that?
Sure. It's just I thought I'd pick it up. It's just 1 minute, but I
But-
thought I'd pick it up now because
okay.
we're on the subject.
Go ahead, just 1 minute.
Just in terms of informing what might be best practice in Russia, from a European perspective, broadly speaking.
Closer to the.
Sorry, broadly speaking, from a European perspective, looking at what best practice you might pick up in Russia, we don't have this formal successor liability, actually. What's a much bigger issue for European companies is the money laundering risk after acquisition. So if you've bought a company that's making profits from a legal contract or a corrupt contract, you are then laundering the proceeds of crime as you distribute the money to your shareholders, and that can give you a mandatory reporting obligation. So I do think there's quite a big distinction between lessons learned from the United States, which are of course very relevant, but also there are different lessons learned in the European market.
Для слушателей одна из...
One of my ideas for the audience can be realized as a result of this couple of panels. We will prepare a publication of articles on this topic, and we'll try to highlight some of these issues, because indeed we need a legal perspective on this issue, and we'll try to reflect that. I now give the floor to Daniel Levin, and well, thank you for your challenging question. We have a very long panel. I hoped that we'll be able to get to the end of it. So please put down your question, and hopefully we'll give you a chance to ask it later.
Thank you very much, and it's an honor to be here. I have a very long presentation, which I will skip most of, and I won't even bother paging through it. I'm happy to provide it to anybody and happy to discuss anything in there that I don't address today, either at a break or at some other time. I'm going to discuss two things. One is enforcement trends and expectations, and in particular a little bit about extraterritorial jurisdiction under the Foreign Corrupt Practices Act, the US law. And then also a little bit about investigations, self-disclosure, and cooperation with the government, again, in the context of the Foreign Corrupt Practices Act. The Foreign Corrupt Practices Act has anti-bribery and books and records provisions. I'll be focusing on the anti-bribery provisions. Turning first to some of the trends that we've seen in recent years and expect to continue. And the simple answer here is I think you're going to see more, and indeed much more, of the same. There's been an increased focus on individual prosecutions. That will continue. There's a lot of political pressure in the United States to prosecute individuals as well as companies. The government, the Justice Department, gets criticized if it only brings actions against companies and not individuals. A large percentage of the individuals prosecuted to date have been non-US citizens. I think that will continue. Corporate prosecutions will also continue, and large fines. Again, a lot involve non-US companies. 8 of the 10 largest FCPA fines have been non-US companies. Again, there's a lot of pressure in the United States to bring actions against non-US companies as well as US companies. There used to be a feeling that there was an unlevel playing field, only the United States was enforcing these laws. That's certainly no longer true, but there's still a lot of pressure to bring cases against non-US companies. Just last night, I noticed one of the FCPA blogs had an article, is DOJ picking on non-US companies and individuals, and the author concluded that they were. You'll see increasing prosecutions and investigations involving agents and joint ventures. You've just heard a lot about acquisitions and mergers and acquisitions and the importance of pre-acquisition due diligence. There's an increasing emphasis, I think, and expectation of some post-acquisition due diligence or continued investigation, and Laura addressed that some as well. That's part of the general trend under the FCPA of the US authorities raising the bar, expecting more and more from companies in the compliance area. And I think you'll be hearing some more about compliance later on. But in general, the authorities are expecting more and more effort on the part of companies in the acquisition area and in the compliance area. And the standards are getting higher and harder to meet. It used to be the action was about written policies and procedures. That's now just assumed to be the case, and there's a lot more emphasis on what you're doing to make sure they're being applied. We'll continue, I think, to see what used to be called prosecution sweeps. When there's a case brought in a particular area, you can expect to see additional cases in that area. They tend not to use that term anymore, but it's still happening. There's 2 reasons. One is it's logical. If one company is paying bribes in a particular area, it's logical to ask if their competitors are doing so as well. And then second, in the course of cooperating with the government, your competitors, agents are often giving information about other companies that may be doing similar things. And you might be surprised to know how much your competitors and agents know about what you're doing. Whistleblowers, There'll be an increased number of whistleblower cases, and I'll talk about that more in just a minute. More international cooperation. This has been really a dramatic change in recent years, and you're going to see much more, I think, both international cooperation and also multi-jurisdictional enforcement. This used to be largely a US game. Now more and more the UK is involved, Germany's involved, China's doing some interesting things in this area. You're going to just, I think, over the next 10 years see more and more cases where the United States is only a piece and often not the most important piece of the puzzle. And I think there'll be an increasing need to try to wrap up these problems, if you can, in one global settlement so that you don't settle with the US authorities for several $100 million or something and then find yourself being asked for additional fines elsewhere or vice versa. Let me talk a minute about extraterritorial jurisdiction. I'll use that term loosely for jurisdiction brought on activities outside the United States. And to some extent, all FCPA actions are extraterritorial. It only applies to fines or to bribes paid to foreign government officials from the United States perspective. The FCPA guide, which Laura mentioned and which is available on the Justice Department and SEC websites, is very good to look at in this area. They talk a lot about at least what the Justice Department's view is of the law. And as I'll get in a minute, to date at least, since there have been relatively few court cases in the United States, what the Justice Department says the law is kind of what the law has been. Most companies have been unwilling to test it and go to trial. Almost all companies have entered into settlements. I think there have been only 2 companies that have gone to trial. As more individuals are prosecuted, you will see more people going to trial and you'll see more judicial decisions, and I do think you'll see some narrowing of some of these very expansive views. But the Justice Department has taken a very broad view of what can give the United States jurisdiction and has staked out a position at least that if an email goes through the United States, if somebody in France sends an email to somebody in Germany and it happens to be routed through the United States, that can be enough to give the United States jurisdiction. Remains to be seen if the courts will accept that. In the civil context, the courts actually have been cutting down some on extraterritorial jurisdiction, but it remains to be seen how that will play out on the criminal side. My own guess is that you will see some narrowing of some of these more expansive views, but you should be aware, at least to date, the Justice Department takes this very broad, very aggressive view of the law. They're also very innovative in using other theories to bring you into their grasp. Agency and conspiracy theories can be used to reach conduct outside the United States, even if you don't have these kinds of transiting emails. If you're acting either as an agent of a US company or in what's called a conspiracy, a criminal agreement with a US company, they will say you're subject to US jurisdiction and have brought and resolved large cases on that basis. So that's sort of the enforcement trends, and I'm sorry to go through this so quickly, but I want to try to keep us on schedule. But I do think you will see more aggressive enforcement from the United States and more increasingly aggressive enforcement from countries other than the United States. All in all, a more challenging and risky environment for companies and individuals in this area. I want to just take a couple minutes on internal investigations, self-reporting, and cooperation. And here it's important to understand, if you're going down this road, the mindset of US prosecutors and agents. My personal background is as a prosecutor and both at the Justice Department and at the FBI. So I don't mean this as a criticism of prosecutors or agents. Not only are some of my best friends them, I was one. But it's important to understand most prosecutors in the United States, most agents, have little business background. And so they don't really have a business perspective when they look at things that are happening within businesses. They're very cynical, very skeptical. They frankly spend most of their time dealing with criminals, and they tend to think everybody's a criminal. And they tend to assume the worst. I early on had a mentor who said if something happens and there's an explanation that it was a mistake and an explanation that it was malicious, you should usually assume it was a mistake because that's more often the case. I can tell you that prosecutors and agents will almost always assume it was malicious. and I'll get to a practical aspect of that in a minute. But, and they tend to see the world very much in black and white. And a key question will be, are you a good guy or are you a bad guy? And when you're in this realm, you want very much to try to convince them you're a good guy. I was asked to address internal investigation scopes. Yeah, I think you've probably all seen reports of just staggering costs of some of these internal investigations. Hundreds of millions of dollars, not on fines, but on investigation costs alone. There are some ways to try to limit these, if you're into this area. You can try to limit the geographic scope. If you have a problem, for example, in Romania, do you need to look to see whether you have the similar problem everywhere else you operate in the world? You can try to limit it by the practices. If you find a bribery problem related to importation of goods, do you have to look to see if you have bribery problems in everything else you're doing in your business? And you can try to limit what you need to review. Do you need to look at every employee's emails, chats, phones, everything else? Or can you try to limit it and do a structured review? We've had pretty good success. I mean, the government will take everything. If you go in and say, we're going to do everything, they'll never say don't. But you can often try to structure it in ways that lets you limit what you're looking at least in the first instance. They'll never say, you know, you'll never have to look at the other stuff, but you can often get an agreement that we'll look at this first, and if we don't find something there, maybe we can stop. And if you have a good working relationship, sometimes that will succeed. We've had some success saying, we'll look at all of the emails of these 4 key people, and we'll do 10% of the emails randomly selected of another group. And if we don't find anything in that 10%, we'll stop. If we do find something, we'll go on and look some more. And we generally had pretty good success getting agreements to, as long as it was reasonable, to limit the investigation in that way. You can also, I think, manage costs somewhat by using internal resources. This is often tricky, but you can often use internal audit, internal lawyers, internal IT resources. You do need to preserve things broadly. The worst mistake you can make at the beginning of an investigation is let documents get destroyed. You can always go back and look at them even if you search narrowly to begin with, and you can avoid obstruction arguments or charges. This is where the cynical view comes in. If something gets destroyed after an investigation starts, you can bet that the government will view that as intentional, and we've rarely been able to convince them it wasn't, but it is a tough, tough challenge to convince them that if something got destroyed, it wasn't intentional. Self-disclosure. There's a debate going on in the United States about self-disclosure and cooperation. There are lawyers who say you should always do it. There are lawyers who say you should never do it. My personal view is it's much more of a tactical decision. Sometimes it makes sense, sometimes it doesn't. We've had a number of cases where we've worked with clients, done thorough internal investigations, corrected the problems, and just sat tight and never gone and talked to the government about it. And the theory that if they later on find out about it, we'll say, look, we did everything properly, we just didn't see any reason to come in and talk. We had good success with that so far, but you never know. Dodd-Frank whistleblower provisions make that a little bit riskier. There's so much benefit now to somebody being a whistleblower that it's more likely things are going to come to the government's attention, which changes this calculation. Cooperation. There are those who say that there's not much benefit from cooperation, and there's some evidence that suggests that they're right. I think the government in the United States is making a greater effort now to show the benefits of cooperation. You've seen this in some recent settlements where they're quite specific about the fact that the fines are lower because of cooperation, and conversely, that the fines are higher with companies who haven't cooperated. It's often, I think, a good strategy. It's not always the best strategy, but it really means cooperation. And we've had difficulty with non-US clients understanding when you say, do you want to cooperate? It really means sort of giving the government everything. And they will be very demanding and expect you to sort of spoon feed them all of the bad stuff. And the worst thing you can do is sort of start out saying you're cooperating and then kind of muddle it through halfway through and kind of not really give them the information they're expecting, because then you'll have kind of the burdens of it without getting the benefits of it. A lot covered quickly, but hopefully I've stayed on time. Happy to answer questions whenever we're taking questions.
That's fantastic. That's the most concise speech I've had. Well, first of all, the first comment from me, I got a little bit terrified, you know, all these sober people with no sense of humor, was watching the world black and white. I was that cynical, skeptical, and aggressive, and it's going to be more aggressive, and extraterritorial effect is going to be expanding, and the volumes of fines are increasing, and you know, it doesn't look like a little bit of Orwell, you know, 90 something. So we have to finally, and then afterwards we have to check any mail, any transaction, every scene, what we have said, what we have seen. I understand it's development, but shall we? Is it a really balanced development? You feel like that?
You know, I think there are a lot of people who would say it is completely unbalanced. I don't think that's really true. I mean, my experience has been that when you deal with the authorities, they can be reasonable, and you can convince them of things. It's a process. It often takes a long time, but they are, you know, they have a view of the world, and they are aggressive in enforcing that view. And their view is that these kinds of payments are simply improper. And what they aren't sympathetic to is the argument, well, we have to do that to do business. Not only is that not a defense, it actually is just the opposite. If you go in and say, look, my client's in India, you have to pay bribes in India, you can't get away with it. They'll turn it around and say, you knew going in that India is a challenging environment. What additional steps did you take to make sure you would not be paying bribes there? And so it's a very challenging environment. It's getting more challenging. I think you'll hear it's getting more challenging with the UK as well. And you know, the message I would give you is that that's not going to change. It's going to get more difficult, more demanding, with higher expectations of the compliance efforts and level of compliance. And that while you can work with the government and try to resolve things, if your company has done things that it shouldn't have done, they are going to be aggressive in expecting a resolution that's going to involve substantial penalties.
Коллеги, ну вот мы услышали...
Dear colleagues, we heard the presentation from a country which is the author of FCPA, and I think this is really indicative, especially because if you've noticed, the word aggressive was said many times, so this is a very aggressive, very effective program. So I should say that this is a trend, the trend which is true not just for the US, but maybe this is a very aggressive and a very important initiative, and this initiative is also being developed in other countries, and I think it demonstrates that the global community is going to pursue this subject without any compromise. And I would say that we do not have such a thing as a safe harbor where you can retreat to wait for the storm to pass, and I think that's why we have the next presentation. I would like to ask Mrs. Robertson about the situation in Great Britain and tell us about anti-corruption legislation and initiatives. As we know it as a UK Bribery Act or Anti-Bribery Act.
Thank you, Alevtina.
Hopefully it's not that scary. Maybe there is a chance.
First of all, I'd like to thank you very much to Alevtina and to the Forum for inviting me to St. Petersburg. Since I was a sort of young teenager reading the great Russian novels, I've always wanted to visit St. Petersburg, so thank you for that. The last time I was in Russia, in fact, it wasn't the Russian Federation, I arrived on a train from Beijing in the summer of 1990 to Moscow, and I have to say, I was a little bit scared. One of the things...
It was as scary as Daniel told us today about the CFA.
Mainly because I couldn't get anything to eat. That was the biggest challenge. I'm going to talk pick up a few of the themes from the other speakers. I'm also going to talk about something that I think we're seeing new in the UK, which is an increased politicization of the criminal process. In England, at least, we like to point fingers at other nations who have more political interference in the criminal process. And I'm suggesting to you that that is something that's happening quite dramatically in the UK, and that's relevant in terms of anti-corruption enforcement, but it's also relevant in terms of financial services regulation and other issues. And the reason I make that point is we have numerous scandals in London at the moment, but they are in three categories, and they are political in nature. So the first one is around LIBOR and FX, which is political concern about the integrity of our financial services industry. We have the phone hacking and bribing public officials scandal that's come out of our newspaper industry. And again, some might say that's politicians getting revenge on the newspapers. And we're waiting for the trial, the verdict in the trial of Rebecca Brooks, who was the editor of News of the World. The jury's been out for 9 days. And then the third issue is there are prosecutions or investigations being run by the Serious Fraud Office at the moment in relation to government outsourcing. Government outsourcing is an issue that is global in nature, and it's also political in nature. Should the state run these services, or should private companies run these services, and what levels of profit should be made? So again, we've got a referral of Serco and G4S by the British government to the Serious Fraud Office. So we're seeing an unprecedented intermingling of politics and criminal prosecutions and investigations in the UK, and I would suggest that that's something that we're seeing spreading across Europe. I'd also just like to pick up on the rise of the whistleblower. We don't yet have in the UK, apart from in the context of competition, cartel, a reward, a monetary reward for whistleblowing. But it is something that is becoming, by those who think about these things, as something that might be legitimate. In any event, the biggest incentive to whistleblow, and I'll talk a bit more about the Rolls-Royce case in a minute, is going to Daniel's point, the rise of prosecutions against individuals. So if you think there is really a serious risk to you personally of being prosecuted in Europe, that's bad enough. You might go to prison for 3, 5, 6 years. You'll probably, in Italy, in fact, you'll just have to go house arrest, so it's not so bad. And in the UK, you'll only have to do half your sentence. But if the real risk to you is to be extradited to the United States, that is really a very terrifying prospect. And that is also a political issue in the UK at the moment, because the United States, we allow very easy extradition, the same as within the European Union, to the United States, and that is causing huge concern amongst the British business community as the United States continues its aggressive anti-corruption investigations. It's also becoming relevant from another perspective, which is the rise of other countries and their enforcement. We've heard about China, and it's clear to me that China is going to use anti-corruption enforcement as an economic weapon in the same way as I would suggest the United States does. And although we've said it in a much more low-key way in the United Kingdom, the government, the Cabinet Office, has made it absolutely clear that the priority of the cases that we prosecute will be where the United Kingdom's economic interests have been damaged. And I think that we're seeing that as a theme across Europe. Poland, I would say, is in the forefront of that within the European Union. I think India is beginning to think about it, and we've seen dramatic changes in terms of corruption enforcement in Italy, in Germany, and in France in recent months. So there's some high-level thoughts picking up on some of the issues that we've been touching on. So for those of you who just want to hear a little bit about the Bribery Act, it does have an extraordinary extraterritorial reach. You will also know that it's been enforced for 3 years now, and we've still not really done anything with it. So should you continue to be worried about it if your company does business in the UK? I would say that you should, and that I think we will see in the next 18 months to 2 years a number of cases coming out of the Serious Fraud Office, which will give us some clarity about what doing business in the UK is and how you can be caught by the Bribery Act. What I would say, though, picking up again on this issue of money laundering, which actually, from a European perspective, is much more frightening from a business perspective than anti-corruption, the cases that you're going to see coming out over the next months, and Rolls-Royce is a particular example, this will not be a Bribery Act prosecution. It will not be a Bribery Act deferred prosecution agreement, if that's what it is. I don't have any inside information, but it will be under the old bribery legislation, and it will have come about firstly because there was a whistleblower, a director who'd worked for Rolls-Royce for 30 years who felt that he wasn't listened to and was concerned about his own personal position. But also the problem for Rolls-Royce is that the acts of corruption have brought profit into the business. That you don't need a conviction for that to be the unlawful proceeds of crime. They've distributed that out to their shareholders. They have a money laundering problem, and they have a very high risk of being prosecuted for money laundering unless they report themselves. So that's why the environment in the UK in particular, but Europe is really difficult, is that if you find unlawful proceeds of crime in your business, to avoid a prosecution, you almost certainly have to report yourself. So it makes the decision whether to self-report or to cooperate that we've heard from Daniel much more nuanced in Europe. I would agree with Daniel that still in a number of the cases that I advise on, we decide to not sweep it under the carpet, but we certainly not, but we do our own investigation and we tie it with a red ribbon and we hope to goodness no one ever sees it. But these decisions are becoming much, much more difficult, both in terms that we've heard from Daniel, but also in terms of the particular money laundering regime in Europe. Thirdly, whistleblowing, and then the fourth element is this increased global exchange of information. So I just wanted to highlight that. The second thing to mention about the Serious Fraud Office, we're talking quite a lot about corruption today, but the Serious Fraud Office is very keen on giving corporates the same liability for acts of fraud, so not just corruption. It wants to have the same powers as it has under the Bribery Act to prosecute a company where it's had a failure of systems and controls to detect fraud. And that's again where we're going to see compliance maturing. I think compliance at the moment can be a danger to business. It can be unfocused. It can tie a business's hand in knots unless we encompass it in a legal framework. And I think it's increasingly dangerous for businesses to sort of have a compliance function that's separate from the legal function. And one of the things that I do day to day is actually help companies dismantle a compliance program that has got out of control. So I do think that those of you working, lawyers in-house, those of you working in compliance functions, I do think you need to be asking yourself, hard questions about, do you really need to do this and why are you doing it? And of course you should be informed by what happens in the United States, but you should also be informed by common sense, dare I say it, a risk-based approach, and also the multiple legal frameworks that are now developing across the world, where it seems to me increasingly difficult just to adhere to one statute, whether it's a statute in the Russian Federation, whether it's a statute in London, whether it's a statute in Brazil. Sorry, somebody had to mention football, right? It's our big night tonight. Just, we're probably going out of the World Cup, but I just thought I'd put that on the table. So that, in terms of developments, I anticipate that we will see an expansion of the Bribery Act into all offences of fraud. I've talked briefly to you about Rolls-Royce. The other case that's very big on the agenda in the UK is GSK, not least because a British director is effectively held under house arrest in China at the moment. And I think that case is going to run and run. And again, to pick up on one of Daniel's points, we used to see the DOJ look at other companies in the sector. We now see that contagion globally. So, UK is looking at GSK, China's looking at GSK, United States begins looking at GSK. You can see it with Alstom at the moment, the French company. The SFO has got investigations now in Poland, in India, in France, and as I understand it, DOJ have also just begun looking at Alstom. So you can see how this contagion can spread. Just in conclusion, sticking to my time, I just wanted to talk to you about two new developments in the UK. Firstly, we've got our new National Crime Agency, which again is going to bring cases on its own account, not outside of bribery, but it's also going to collect data, this kind of data that you can collect globally now in terms of companies that are in trouble, whether it be individuals who've been in trouble. It's going to encapsulate all sorts of information that it's going to circulate to our various regulators. So that will include our competition regulator, the Serious Fraud Office, and indeed other regulators that we have. So I think that's going to be quite an interesting development in terms of an increased sophistication in the sharing of information between our agencies domestically. But I also emphasize the United States has been our closest partner for the last 20 years in terms of sharing information, international gateways being open. But I can tell you from first-hand experience, notwithstanding there can be issues between the Russian Federation and the UK, there is actually a very high degree of sharing of information between our two countries, and that applies across Europe. And I heard recently the director of the Serious Fraud Office has said that the sharing of information between China and the UK is becoming increasingly mature. And the reason why that's particularly interesting is because in Europe and in the UK, we will not extradite individuals where the death penalty can be take place. The death penalty is available for acts of corruption in China. We've already seen 2 acts of execution for corruption. And the Chinese are beginning to understand that if they want extradition, which they do because they want to show their might, they're going to have to moderate the types of punishment that they hand out, and execution clearly can't be one of them. So, you know, I think we're just seeing things moving into a whole new level. And if I was a director of any multinational company, one, I'd want a very good D&O policy to make sure that I could have the lawyer of my choice, you know, wherever I wanted. But I would also want increased, you know, engagement with compliance procedures, making sure they fitted into a legal framework, and making sure that they stand up to the test of whichever regulator might come knocking. And then the final point in my last minute is we brought into force in February this year deferred prosecution agreements. The principle follows that of the United States, but it has much greater judicial oversight. So it's not, it doesn't permit what you see in the United States, which is effectively a deal between the company under investigation and the DOJ, and then it gets presented to the court. There will be much more transparency, much more openness, and the court will have the ability to say no to that. So what's hoped during the course of 2014 and 15, you will see some of these deferred prosecution agreements coming through, and you will start to get some insight as to what the penalties should be, you know, what level of directors should be prosecuted, and what are the criteria, because at the moment we just have some guidance about what are the criteria for a deferred prosecution agreement. But I think that's also something to watch in terms of informing yourself about how different countries apply principles to these. And of course they're not going to be directly applicable, but for those of us working in the front line where we often don't know the exact answer, whether it be legal or compliance or ethical, I think it does help to look at this widening body of jurisprudence, widening body of cases to help us make the right decisions for our companies. Thank you very much for listening to me.
Well, I'm very fortunate to have a very disciplined speakers in my panel. I did, let's say, я для себя
for myself, I have prioritized several statements. Compliance as an economical weapon.
And the second is about the danger if we are not doing this within legal framework, because it's becoming the topic in itself. Но с другой стороны, коллеги, я бы сказала, что мы идем так.
But on the other hand, I believe we are developing logically from that dark black and white picture where we have death penalty.
We're becoming a very scary panel today. Следующий спикер. Я передаю слово господину Лафицкому.
Okay, we are moving on. I would like to give the floor to Mr. Lafitsky. I don't know. I would like, first of all, I would like to thank Vladimir Ilyich to join us at this panel discussion. In the beginning, our starting point, the original idea was it was order by the President of the Russian Federation issued in April on fighting corruption and plan to fight corruption in Russia in the near future. And this topic has been extremely important, and a number of clear proposals were included in the area of reforming or clarification of Russian laws and working it out in the context of international principles. And I hope Vladimir Ilyich will tell us what we are going to expect here in Russia. Are we going to have a death penalty, or are we going to have monetary compensations for whistleblowers and so on? What should we expect? Thank you very much. In order to know what we are going to have, we need to know what is happening now. In the past years, lots of international organizations have adopted laws and documents related to compliance, and this refers to corporate activities and individuals. In April 2005, the Brazil Committee on Banking Control issued recommendations in the area of compliance and the compliance functions in banks. And in 2007, the Bank of Russia distributed this document to all Russian banks for execution. Organization of Economic Cooperation and Development adopted several documents in the area of compliance. For example, internal practices, best practices, audit and compliance. And the last draft of this document appeared in 2010. And this trend is followed by a number of countries. For example, the UK Bribery Act, it was issued in 2010, and it is not only in the area of criminal law, but also it covers issues of internal structure and internal procedures of companies, and this is a very wide law. In 2013 in Brazil, they adopted a law on clean companies, and it is already effective. And we can say that we are observing a global tendency that this sphere is expanding. And at the same time, not very many private companies are ready to become part of this tendency. Of course, I'm not speaking about banks because compliance functions are introduced there. This is mandatory. In Russia, in this country, we have about 4 million legal entities, companies, and most of them are private. Privately owned companies, but not many of them introduce anti-corruption practices, although this is stated by the law, anti-corruption law, and this in this case, in this meaning, American Bank Association had a survey among its members whether they know the convention, anti-bribery convention, and 40% of all respondents didn't know anything about this document. So we are not alone in this respect. And this convention aims at anti-corruption activities not only in corporate practices but also in private life. And this is a 12th convention of the United Nations. So this inability or not readiness to accept compliance can be explained by many reasons. First of all, very often they don't understand the danger of this, and more often people don't want to change anything. You all understand that corruption is a source of, it is an endless source of lots of good things, and it is very easy to get it. In Germany, for example, lots of organizations and private companies, they don't want to introduce compliance in their practice. because they explain this because none of the employees is susceptible to corruption. But corruption is always two-sided. One side gives something and the other accepts. In the public area, these are officials, but there are business people on the other side, and they try to promote or to protect the interests of their organizations or companies. So this is a two-sided coin, and we cannot separate that. And this vicious circle should be broken. And that is why we introduce these compliance functions in private companies. We want to stop this stream because this spoils and damages, destroys the sector. And all lawyers or representatives of private companies, we all know that corruption exists in this private sector, and it is even more so in comparison with the private sector. And this refers to procurement, to provision of services, hiring, selection of counter-agents, and so on. There are so many lawyers who can mention lots of cases like that. But we need to focus not on this, but on the driving force of compliance, because we are here trying to understand what stands behind this notion. One of the reasons for that, because a law has its limits. So the law cannot enter lots of areas of public life. So there are interstate barriers, and there are certain lines, and the law cannot step over. So the law cannot affect our way of thinking, our mentality, and the law cannot regulate certain relations because it is like in the Middle Ages. This is a different county and a different province, but we do have to intrude, to join it, and we need to fight this problem of corruption. And the second reason I would like to mention, lots of big companies, they are comparable in terms of the number of staff and their capital with some countries. For example, Walmart stores, this American company, 2 million people work for this company in more than 100 countries of the world. More than 100 states of the world, they have a smaller population. And top countries, top companies of the Forbes list, they can be comparable with certain states. And of course, we need to regulate and reach a balance. And definitely compliance is a sort of a self-regulating mechanism. That is why it is so widely introduced. We can speak about other reasons of compliance, but we can state only the following. The compliance is here with us, and it won't be gone. It will be gone only with the civilization we have created. And of course, the matter is what we are going to do. Definitely, we need to develop some global methodology and strategies of compliance that will be covering all spheres of a private company's activities. And they shouldn't be contradictory by nature, because there are different strategies how to beat compliance in banking sphere, for example, in the technological sphere, in the anti-corruption sphere, and so on. And this is really a must, and there should be some global agency, maybe like the United Nations, because specialized strategies of compliance, they have appeared, and for example, the Organization of Economic Cooperation and Development is developing them. Exactly 2 weeks ago, 14 days ago, there was a meeting of an anti-corruption academy, and I'm a member of the scientific council of this international academy. It was established under the United Nations, and we were discussing the program of our activities, and one of the things we discussed, it was a development of a model strategies of compliance for private companies, and lots of research organizations will be participating in this work, and I would like to invite you, participants of this panel discussion, to join this work, because of course we have a very great responsibility in this respect, and we need to develop other specialized compliance documents. And I'm saying again, it shouldn't be only anti-corruption, because yes, we have better experience in that, but compliance is necessary in technological security sphere, and this is even more important than in corruption sphere. Another significant area is compliance in environmental safety area, and so on and so forth. So there are so many spheres where compliance will be introduced, and we need to prepare ourselves for that, and we also need to promote and enhance this compliance, not to make mistakes and not to take the wrong way, because there are threats like that. For example, in the area of anti-corruption, we have so many professional fighters with corruption, and they fight so hard that it flourishes even more than in the past. So, and I want professionals in this sphere with a sober mind will develop all these documents so that they will be good for everyone.
Thank you very much, Vladimir. As practical people, I have a couple of practical questions. Well, to answer your question, there will be no death penalty. Thanks. I have more practical questions for you, other than the death penalty. Can we expect in Russia a subsector of law to regulate this? Will Russian law of anti-corruption become extraterritorial one day, and will consider these relations in other countries and use fines? I will not specify the exact countries for which fines will be applied. There's no such country that is totally free from corruption. Soccer teams, you know, they never give away the best player. Like in the States, when Obama became president, then the Illinois governor started selling seats, Obama's seats in the state Senate. So corruption is omnipresent, and if you look at the data from Transparency International, China and Russia are the last and second last in terms of corruption of their companies. That's great. So my question to Transparency International is, who do they give bribes? Because if you take the turnover, the sales that they have, they're either with the US or Europe. Because if our companies give bribes, then who takes them? It's probably they take them. So corruption is everywhere. Corruption needs to be fought, and it should be fought on both sides of the ocean. And any sanctions in response, no, rather good faith, because you need to fight corruption out of good faith. So sanctions will be applied in this country too, and that's the right thing to do, because corruption, you need to fight corruption without any attention to national borders, because corruption sees no borders, and corruptioners must be sought not only in Russia but in other countries where they're trying to hide from our justice. Thank you very much. We will now move to anti-corruption, or rather anti-corruption initiatives in international arbitration, in particular representatives of the International Arbitration Court in Paris will tell us about the latest trends in international arbitration in this area. So over to Vladimir Faleyev. There's the so-called red flags to pay attention to, but I'd like to make another step forward. Companies investigate, find red flags, and compliance officers issue recommendations for contracts to be terminated. The other side, the other party, may disagree. They say, okay, we had our own investigation completed, we didn't find anything like that. So what's the legal grounds for the contract to be terminated? If one side says, we identified red flags, and translating it from legal language, this is a indirect sign that the contract was based on corruption efforts, or is covering corruption. So we're moving from corruption, the corruption area that lives in its world, in the world of people who look at everyone as criminals, in black and white, and then we go to court, and one of the sides says that I have serious grounds to believe that the other side is involved in bribery and other wrongdoings. The other side denies that, and the judges say, okay, if you said it, that's good, but you need to prove it. The fact that you have any indirect evidence of a contract being based on bribes or other unethical conduct, it's got to be proven. If you look at the practice of international arbitration courts, and you will hear more specific examples, there's an interesting trend lately in the world of international arbitration. In the 1960s, there was this Landegren case, a well-known one, who said that if corruption is involved, then it's not subject to arbitration at all. Go to any courts of justice. But then the situation changed. Even if there is any corruption or fraud involved, we still have jurisdiction if there's an arbitration agreement in view of the arbitration agreement. Now, most judges base themselves on the fact that it's not sufficient to claim there's corruption, need to prove it. Now, proving corruption requires higher standards of proof as compared to other types of claims, and that's a problem, because we are all well aware that people involved in corruption activities, they are well aware that this is a crime, and they hide any potential proof. They will never make a contract stating that someone is supposed to pay a bribe to someone else. So there's no written proof of bribes. Witnesses usually never say there was a bribe, and no one wants to witness against oneself. So the party claiming there was corruption is nothing but indirect evidence, or red flags, as they call them. So in a world where international arbitration proved de facto corruption, up until recently, it was mostly cases where the other party recognized or accepted World Duty Free against Kenya versus Kenya case, where World Duty Free in the arbitration court told how he gave a bribe to the president of Kenya to be allowed to build a duty-free shop in the Kenya airport. And Kenya agreed that that was the case. Now, the recent trends see more and more cases where judges are paying attention to suspicious deals, even when the other party does not claim that. So we have cases like another instance in our ad hoc arbitration in Stockholm involving Russian companies, where the Russian party claimed payment for preparing some technical documentation. It all looked pretty strange because it was unclear what documentation was given to whom, and the judge said, please present specifically what you did. Do you have a transfer act or report? And the party was unable to do that, so the judge dismissed the claim. And today, there's more and more cases, and Christensen will tell you more about it, where judges shift the burden of proof, whereas the classical position was that it's insufficient to claim there was corruption, you need to prove it. Now, some of the cases can see decisions or rulings where prima facie is sufficient. So proving that a contract is covering corruption or is based on corruption, then the burden of proof goes to the other party. The other party is supposed to prove that the contract was not involved in corruption. What documentation was prepared, when it was transferred, and things like that. And I believe that this current trend in the world of international arbitration, where more and more judges focus on these corruption cases, more and more cases can see a shift in the burden of proof to the other side, where you have to prove you're not corrupted. It's not up to me to prove that you are corrupted. And here I'd like to give it over to Chris Finessen to provide more examples to you. And we have a bulletin issued dedicated to corruption. There's a review of judicial practice, and my colleague it can give you some good understanding of how cases were considered where one of the parties claimed there was corruption. Thank you. Thank you, Christian. Please, over to you. Thank you very much. And thank you for the invitation. This is a great honor for me to attend such a high forum. Like I said yesterday, don't worry, I won't speak Russian. I, of course, speak English. I just wanted to explain to you that I was late, and unfortunately I have to leave early because I am invited to speak at a different panel at the same time. So I think you deserve a round of applause for someone who's, where are you from? Argentina. Okay, and he doesn't speak Russian very well. That's what he says, someone who's not living in Russia.
I'd like to add a couple of examples to what Vladimir said, and then to touch upon very quickly on two additional issues. Examples, so you can have a real idea of how tribunals have reached these conclusions when either reversing the burden of proof or when setting a lower or higher standard. when making these determinations. There was an award, an ICC, all the cases that I'm going to mention are ICC cases, except for one, but I will make that clear. So there was a case in 2005 that was related to the sale of oil in an African country, where the tribunal found that there were some abnormality circumstances regarding the underlying contract. And those abnormal circumstances, of course, led to the finding that there was a corruption involved in the obtaining of that contract. So to get to that determination, the tribunal took into account the following elements that I'm going to say. The first one is that claimant was unable to produce evidence that it had performed any of its obligations in relation to the agreement between the two parties, the agreement that was obtained by these illicit means. The agreements were negotiated over a very short period of time, which was strange given the complexity of the transaction involved. The claimant received a very high commission of 15% of the full price of the contract, which was excessively high. And another indirect circumstance that was taken into account was that a finding of corruption was in line with the state practices or the state that was involved in this contract. So on the basis of this very circumstantial evidence, if you want, the tribunal took a proactive approach to lower the standard of proof required in order to facilitate these findings, because as Vladimir was saying, it's almost impossible to find a contract by which the parties will say, yes, of course, this is a bribe. Then we have another example on a different approach, where a tribunal in 2008 said that the standard of proof that should be applied to this kind of determination should be higher because of the significance that goes along with such a determination. So they said that they requested clear and convincing evidence beyond any reasonable doubt. So in this case, it was again, it's very common to see these kind of situations in cases involving an agent and a commission. Here it was again the same kind of transactions. Pursuant to which, what the tribunal's finding was that the commission was paid by the respondents to the claimant for them to be used as bribes to bribe state officials in order to win a contract. So here, what the tribunal considered as red flags are the following elements. First of all, the claimant's refusal to comply with the tribunal's order for him to disclose his bank and tax records, from that refusal, the tribunal drew adverse inferences. The lack of credibility of claimant's testimony that he was not able to produce these documents because his wife had stolen them. The fact that claimant's activity was as a livestock breeder, and he didn't have any experience in the seismic field, which was the relevant field in this contract, that could justify a very high commission. And last, but probably the most important element, was claimant's inability to prove the legitimacy of several wire transfers from his account to different relatives of the same state official. So here again, we see this sort of reversal of the burden of proof, because it was for the claimant to prove that the legitimacy of those transfers. So this, as to the examples, I just want to mention very briefly two additional points. One is the legal consequences of a finding on corruption, and the other one is the role of arbitral institutions when it comes to dealing with this kind of difficult topics. As to the sanction of, Vladimir explained very well, now there's no longer an issue of jurisdiction here. All tribunals accept they have jurisdiction. These claims are arbitrable, and the normal consequence whenever a tribunal finds there was corruption involved is to declare the contract null and void. That is quite clear. There are many legal instruments or treaties that provide for these solutions. For example, there's a United Nations Convention Against Corruption, which specifically states that states could incorporate into their legal proceedings the possibility to annul contracts whenever there is this kind of illicit conduct. So that is quite clear, and tribunals have always recognized these instruments as forming part of the transnational public order. But there's something else that is, I think it's interesting to bear in mind, which is the fact that it's not only the fact that the contract is going to be annulled, but that decision may also have some adverse consequences for the parties, because in a way, in cases where both parties have agreed consciously to enter into a corrupted contract, then it's very likely that the tribunal will dismiss all claims, and it may happen, as it did in at least 2 cases, that the respondent or that one of the parties that obtain payments to use for bribes, for example, that they will not be ordered to reimburse those payments to the other side. I'm going to give you just one example on this point. It's an ICC case. The tribunal found that the commissions, again, were to be used as bribes. So it declared that the contract was null and void. But then the tribunal added that since the respondent knew that this was the purpose of the commission, it could not recover the monies paid under that agreement, since what has, and I'm quoting, what has been given with illegal intent cannot be reclaimed under theories of equity or unjust enrichment. And there has been very recently an exit case where the tribunal reached the very same decision. And I'm going to read very briefly, because I think it's important, the consideration made by the tribunal in this case. It said that the tribunal is sensitive to the ongoing debate that finding on corruptions often come down heavily on claimants, while possibly exonerating defendants that may have themselves been involved in the corrupt acts. It is true that the outcome in cases of corruption often appears unsatisfactory because, at first sight at least, it seems to give an unfair advantage to the defendant party. The idea, however, is not to punish one party at the cost of the other, but rather to ensure the promotion of the rule of law, which entails that a court or tribunal cannot grant assistance to a party that has engaged in a corrupt act. So that as to the legal consequences, and going to my last point on the role of international institutions. I think the first question, normally ad hoc arbitration is seen more as a means for this kind of fraudulent schemes because there is no control by an institution. It's more difficult when an institution is involved. On the other hand, very sophisticated parties may want to resort to an institution precisely to pretend to obtain more legitimacy of the process, even if the whole deal is illicit. So the first question an institution must ask itself when it's at the very early stage of the case, when it receives a request for arbitration, whether to proceed with its registration. I'm going to give you an example of a case that happened 2 years ago. There was first a mediation under the ICC rules. At the mediation, both parties agreed to settle the dispute, and they agreed that one of the parties would pay some monies to the other, that there's going to be an arbitration run by a sole arbitrator who's going to be the mediator in the mediation, and then they would ask for a word by consent. So they came to us with all those requests. So instead of proceeding with the registration of the case, the Secretariat of the ICC went back to the parties to say, well, why do you really want this to happen? Is there any dispute? Because one of the requirements under Article 1 of the ICC rules is that there must be a dispute. So the explanation given by the parties was that one of them was a state entity, and for internal reasons, it needed an award by consent in order to be able to process those payments. The mediation didn't, the settlement agreed, and the mediation apparently was not enough. So on the basis of that explanation, we let the case proceed. But, and this is my very last point within this topic, there's also something important to mention, speaking about award by consent, because probably the award by consent are the most dangerous, if I may say, instrument that arbitrator may offer to, in a way, validate this kind of illicit acts, because it's very simple. If the parties agree, then the tribunal will render it, and then they will say, but I have an award that validates the settlement. So one important feature about the ICC rules is that any award rendered by a tribunal has first to be scrutinized and approved by the ICC court. Vladimir is one of the vice presidents. So whenever we get an award by consent, well, first of all, the rules require that the tribunal agrees to render that award by consent, precisely in cases they smell something is not going well. Then, at the process of the scrutiny, the court will normally request the tribunals to satisfy themselves that there's no issue of public policy that would prevent them from rendering these awards, and only then the court will proceed. And I'm finishing with an example. There was a case like this where the tribunal submitted an award by consent at the request of the parties. So when we got it at the court, one of the comments that the court made to the tribunal was, well, but we haven't seen the settlement agreement, and you haven't seen the settlement agreement either. So how are you ordering the parties to comply with the terms of those settlements when no one has seen it? So the court asked the tribunal to go back to the parties and to ask the parties to provide a copy of the settlement agreement. And at that point, the parties withdrew the request for an award by consent on the grounds that the settlement was confidential even for the tribunal. And so the case was over there. Thanks.
Thank you, Christian. So basically, I waive my further questions because we need to proceed quickly. Я передаю слово.
That's why I would like to give the floor to the representative of China. We've already heard how this topic is developed in the US, in Great Britain, and I think that Elizabeth mentioned new developments in China. So I have to say that we do see that China is undertaking measures that indicate that we can expect a new player on the so-called compliance market. So I do hope that Wang Xiaoping will tell us what the Chinese corporations can expect, what sort of developments is this topic undergoing in China, and he'll also tell them maybe they will have some extraterritorial effect.
Everybody. My name is Wang from China. I'm a Chinese lawyer of the Guangdong. Our law firm is one of the biggest law firms in China. We have more than 700 lawyers whole China. So we are doing a lot of legal business to provide service to the Chinese and the foreign companies. During such work, we are, of course, to engage some cases or even know some cases about the compliance issues. Probably the audience, most people come from Russia. Probably you might think the Chinese practice is far from here. But I want to mention that just last month, the President Putin come to China to attend one international meeting. But on the same time, they have a very big delegation and have a big talking with Chinese leaders. Of course, they got a lot of the agreement each other's. The typical one is the Gazprom to decide provide natural gas to China after 30 years. That deal could be mentioned about $50 billion. And that means the relation between China and Russia and going to closer and closer. So I think there's some business will be going on your companies or firms. And today I want to say something about compliance in China. I prepared the whole picture about the compliance, but the organizer asked me to concentrate on the corruption. Of course, the corruption is a big issue also in China. And as you know, China during the past 30 years is from a planning economy to the market economy. I think most of the people from Russia is very familiar with such a situation. And so that's the same time, during the 30 years, the legal structure about the economic laws is established. Eventually, 30 years ago, there's almost nothing about economic law or commercial laws. So right now, the whole structure is established. So on the same time, the anti-corruption is also established. It's economic laws, yeah. So we do not mention that too much, anyway. Just a moment. And eventually, the anti-corruption. Just a moment. Yes, anti-corruption laws mainly come from in China come from such laws. One is anti-unfair competition law. They are, of course, covered all unfair competition activity, and also mentioned that corruption. Eventually, that law is established in 1993, more than 20 years. So that means from then, the anti-corruption is a really big issue from China. Another one is criminal law. Eventually, the criminal law is more before the China become the market economy. Of course, there are some anti-corrupt for the officials. There is something regarding the official corruption. That's a very long time ago. Of course, after that, the criminal law could be reversed and until today. So there's many detailed regulation about the anti-corruption. Another one I want to mention, because there is another speaker mentioned that is the Anti-Corruption Convention of the United Nations. Eventually, United Nations passed one convention regarding the anti-corruption, and that is 2003. Eventually, the United Nations established one special committee to draft the anti-corruption convention. So in 2003, the United Nations passed this convention, and China became the first countries of this convention. And also, China, from 2005, the Congress passed this convention. So the convention now is regulated to the Chinese corruption issues. So probably from then, the Chinese government want to make and to do more and detail about anti-corruption activity. So there's a lot of things you can see. In China, there's some typical activity. Of course, there corruption will be going on so many fields, but you can see that especially the medical product selling and infrastructure and development project, and consumer products distribution and retail, and tourist guide is very special in China. Probably you can find it here too, and education and other professional service. So there's a lot of things is going on. I mean, anti-corruption activity going on in China, but the authority is paid a lot of attention to such a field. One thing I really want to mention is foreign companies that's doing business in China, because that's really related to the anti-corruption issues. Eventually, after the China became an open door to the foreign countries, foreign companies, they are invite a lot of foreign companies like 500 Fortune 500 companies who come to China to invest. So then, during past 30 years, China adopted one system of the really favored to the foreign company to do business in China. And so that's in the same times, even though there are some laws regarding to the anti-corruption, but the enforcement to foreign companies is less conduct or very not so heavily conduct. But after the China get in the WTO systems, so they almost every rule regarding commercial activity is same or similar with other countries. So the treatment could be equal. That means the law enforcement to the companies is become equal. Of course, as foreign companies, there are some risk management the conduction. So in my hand, there's such kind of Siemens business conduct guideline. In such guideline, they also mention such they pay attention how to avoid the corruption and bribery. But in China, eventually there are two authorities to do the enforcement. One is the state administration of the industry and the commerce. This authority, they are very hard to find in other countries, but this authority is very, very useful and very, very active. That authority always going to do the enforcement of the administrative enforcement. So they are to find something going on in the commercial activities. They do some administrative punishment to such the activities. If the activities really, really influence the market so much, the Minister of Public Security, the police will come up to do the investment investigation and go through the justice procedure, the criminal procedure. not work. Doesn't work. Oh. Okay. Okay. Here I want to mention some cases. It's multinational companies. One is Lucent Technology. Is 2004. That is some of the Chinese manager, of course, Lucent Technology China, the manager, to make some bribery to the official to make some deal in China. But then the Chinese authority didn't do so much the punishment to such case. Of course, the companies itself doing something to resolve the problem. And another one is Mercedes-Benz. It's 2010. Eventually, that is the case. It's a multinational case that United States government conduct one investigation, and that case involved 20 countries, and that means they Mercedes-Benz doing such corruption as among countries, not only one countries. So then the China will be to cooperate with the others. Okay. Recently, that is GlaxoSmithKline, the other person already mentioned. That is a very serious issues, serious case. So now they already to go through the criminal procedure. So that means we are now in China, we have a very good, in some meaning, the law to regulate the anti-corruption activities. So I hope the company doing business in China have to pay much attention to such field. Okay.
Thank you very much. Я извиняюсь, мы немножечко, в общем, выходим с графика.
Sorry, I apologize. We are very short of time. So we have used up all our time. We have two more speakers, and I believe we'll have enough. Diaz Asanov, who is compliance officer from Siemens Russia, who will be speaking about practical aspects of contractual terms, and if I'm not mistaken, you will be speaking about Siemens contracts and agreements, and we will be very grateful if you are precise and concise, very brief. Thank you, Alevtina. I'll try to be very brief, but nevertheless detailed. As you said in the very beginning of this session, yes, there is a certain misunderstanding of the role of compliance in its relation to legal activities and legal support of the companies. And there are certain difficulties how compliance department and the law department should be coordinating their work. Apart from extraterritorial aspects of various countries, and we heard a lot about it in the Russian law, number of changes have been introduced. For example, there's a new article on combating corruption in the federal law, and this is effective for all companies. And also there are recommendations of the Ministry of Labor, very detailed instructions how companies need to follow all compliance rules. After analyzing this, we still believe that some legal aspects should be further elaborated. First of all, there are no mechanisms or no enforcement mechanisms if these requirements are not fulfilled. In a number of cases, in several regions of Russia, companies were enforced to take certain measures inside companies, and I know that the Ministry of Labor sometimes, after auditing, they took decisions for those companies to introduce compliance procedures. So these are already practical things related to how these recommendations should be introduced and what liability may follow. Speaking about specific practical examples, I would like to give two examples. First of all, it is cooperation with law enforcement authorities, and the second aspect is due diligence of counteragents and special terms in the contract. Speaking about this cooperation with authorities, this is compulsory. Companies should report about all cases of corruption cases, and if I'm not mistaken, in the Russian law, this is true only about serious offenses. And in our practice, we are lucky enough not to see bribery or corruption cases all the time. Sometimes this is a matter of fraud, something like that. And I know that lots of companies don't know how to deal with that, and they do not report, for example, about their internal investigations. Our American colleague mentioned that even in the United States, there's no one solution to that, and in each specific case, they take a different opinion. We don't have Dodd-Frank law or similar law providing compensations to whistleblowers, and I believe it is very important to understand from the legal perspective, if we do have such a notion of whistleblowers, how are they going to be protected? How are we going to call them in Russia? And if companies have their own compliance departments, and if they do a certain internal investigation, and what if their employee decides to report later if they're not happy with the results of those investigations. And in practice, we see that sometimes prosecutors come to an office, they start their work very aggressively, and when you approach them and say, I'm from the compliance department and I can help you, they said, who are you? What is compliance? And then you explain, I am direct on complying with all the norms. Are you a lawyer? No, I'm from compliance. Can you specify detail? I fight corruption. Oh, right, that's clear. Then you are a colleague of ours. Then tell us, where do you have all that money you launder? And give us the names of all the persons involved in corruption activities. And this is, I'm speaking about a real thing. From practice, and again, how do we cooperate with such people and with all these authorities? Conflict of interest. This is a very interesting topic. Why? We are speaking about it when we discuss anti-corruption laws, because when you join company and you see that bribery, which was very common a couple of years ago when there were some untransparent consulting agreements, but now we see that this is something from the past, and now we have more sophisticated schemes, and there are some daughter companies or something else. So very often it is a matter of conflict of interest. And I would like to draw your attention to the fact that in our labor laws, there are no norms related to that. So if someone doesn't report about such cases, it is very difficult to make this person liable. There cannot be any disciplinary sanctions, and you cannot fire such people. And sometimes for companies, it is easier for companies simply to terminate the labor agreement with this person in an agreeable manner, and but they are never fired. And such people even get good compensations, and they can find another work, and it means that later these people may continue their corruption activities. So it is important to synchronize our labor laws, because then we will be able to be logical. And then another point, this is checking counteragents, due diligence of partners and related parties. What if this related party is approved? We have all the documents about this company. Okay, they signed all possible requirements, and that they are ready to be compliant and whatever. So they wanted to pass through our internal due diligence, but later it turned out that this company was involved in some corruption activities. Are we liable? Are we as a company checking them? So why were we doing that? Just to put a tick, okay, we did that, or we really wanted to find some reliable partners? So here there are certain difficulties when we work with our antitrust agencies, because sometimes when we have a very stringent due diligence, this antitrust committee says, oh, you are trying to influence their work. Then, speaking about counteragents, partners, and all these requirements, we have very rich experience in that. It is important to to explain to these future partners what compliance is. This is especially important for those companies who know nothing about compliance, and sometimes they are shocked when they read all clauses of the agreement, when they read that we can visit their enterprise, and we don't have to give them any notice, and we can check all their accounting documents and so on. And some companies ask to be paid for that. And so there are so many questions, and it would be interesting to know what if some companies have actual experience of that, but when it is done in order to ensure great results. When we introduced it, there was no understanding on the part of our partners, because they kept asking, "What is the reason? Please tell us. Don't beat around the bush. Are there problems? Did someone call you? Did someone inform something?" And we were saying, "No, this is our obligation. Yeah, we have to do it now. We are performing this work in line with the Russian laws." And I believe it will take some time until this practice will be accepted and acknowledged in the market. I'm not speaking about the big companies. They do have compliance. But I'm speaking about partners and suppliers and manufacturers. We do have to work with them. And termination of agreements. In case of some corruption cases, yes, we can discuss it for long. We try to link this not to only corruption cases, but we have the right to terminate the contract, of course, with an appropriate notice. And if the company will sue us for libel later, it will be very difficult to prove. Especially if we're speaking about public procurement, so after certain decision of the court, because they proved that they were innocent, we might even have to work with them again. So this is very briefly about my area, so I can respond to your questions later. Thank you very much, dears. Yes, so you are great in packing your speech with all these details. Yeah, every topic you mentioned, yeah, it is worth full-time discussion. We also have representatives of PVC. I asked them to speak about what types of audits are appropriate for such cases. I would like to give the floor to Anna Zaloeva. this is probably a signal that we should stop. And we are going to put it all on paper. We will try to summarize all practical aspects of this work, and there will be more practical recommendations from Dias and Anna. Yeah, I'm going to say a couple of words, because in a couple of minutes a new session will start here. Yes, I absolutely agree with Dias, the previous speaker, and Vladimir gave a very good presentation. When all parties meet in court and when they have to prove whether there was any suspicion about corruption, but it is all on the tips of our fingers. For example, I have a forensic specialist here. They usually do that audit inspection, and they check whether there were some violation of money laundering laws or corruption laws. And as Dias said, there are several steps. First of all, when a Russian company or an international company who work here in Russia and they try to work in some agents or distributors, or they're signing contracts, and at first partners, they roll their eyes and say, what, compliance? Why should we sign such agreements with all these clauses? And as for practical examples, these possible partners, when they don't want to sign it, then there will be no agreement. If such counteragents don't want to sign such agreements, then something might be wrong. And secondly, if a company is a monopoly, and this is what Dias spoke about, it is antitrust law regulation, you won't be able to say no to this company, and then it is a matter of some legal procedures, litigations. I don't know how our state will be treating this when you do some preliminary analysis and you realize that you don't want to work with these distributors or dealers, but there are no formal grounds to say no to them. So this is a serious problem. And I'm just giving you bullet points because we have no time. The second stage of our work, it is when we do have this agreement already, and the companies that would like to have an internal audit, they go to consultants, and they ask consultants to check what is happening inside this company. And then there's a serious question, what shall we do with some information that we have found, because we always sign confidentiality agreements, and this is signed with a consulting company, and okay, they realize that there is a risk that some individuals, or maybe the company, was involved in some activities, and then it is a serious problem. How do we share this information with the client? And probably there are cases when three-party agreements, confidentiality agreements, are signed. And then the last phase, this is already meeting in court. This is what Vladimir was speaking about. Before we go to court, yes, there are serious discussions of whether there are any grounds for this company to be suspicious about certain corruption schemes or so on. And this is very hard to prove. Now I'm going to pass over to Inna, who is our forensic specialist. So she is doing this audit herself. Okay, just 1 minute. 1 minute only. I can say that I, with my own hands, do this work. I do compliance audits, and these questions. Okay. If there is an antitrust clause, what do we do? Yes, we do this review and due diligence, but it depends on how the counteragent is motivated to work with the client. If they don't want to sign this agreement, then it means that they want to have any business. But if they do want to have this business, then they open their books and documents and so on. Sometimes when the client has a suspicion that there's something wrong with the counteragent, then they request for written clarifications. And if the client does not agree with these written clarifications, then maybe they decide not to continue their work with this partner. This is one way. And the second way is when the counteragent says, okay, we want to work with you. You want to get access to our books and our accounting systems, but we are not ready to open up to you. But we are going to hire consultants ourselves. Okay, we will discuss the scope of work with them, and if you agree with that, then that consultant will do an audit, and then we will give you a report. And in such a way, we still remain in that confidentiality sphere. So this is my answer. Yes, so we do have such audits. The most difficult thing is to get access to information, but if you really wish it, then it is possible. Thank you. I would like to thank all who stayed with us. Really, thank you so much, and we hope that all this information has been useful, and we are going to prepare a brief summary of all this. Thank you very much.